So we are dealing with CPC. Overview, if I can say what is CPC and why we are studying CPC, what is the reason behind it, or why we are studying, or why this subject has been there. My voice is audible to you all.
Yes, sir.
First and the most important reason is that when there is a right, there is a remedy. Ubi just a remedy. When there is a right, there must be a remedy. If your right has been violated, then you must have a remedy. And to get the remedy, what process you are going to have, in which process you are going to file the dispute, if any dispute has been taken place due to which your right has been violated. In the civil case, we have CPC. So the balance of interest has also to be seen in a very proper and in a very important manner. What is balance of interest? Balance of interest between plaintiff and defendant. If the right has been violated, then how the right has been violated? And if the defendant is saying that no, there is no violation of right, then how he is saying that there is no violation of right? All these things has to be seen in CPC. CPC is a procedural law which is to be there. If any substantive right of any legal right has been violated, so to file a case, in which manner you are going to file a case and how you are going to file a case under civil law that deals with the CPC. So the CPC is the principles of the legislation which is governing the procedure or the adjudication of civil disputes in India, and it also provides the framework within which civil court operates and resolve the dispute between the individuals. So there are two parts. One, it is dealing with the code that is known as substantive provision, that is from section 1 to 158, and other that is first schedule. It comprises of orders and rules, and the basic or the key basic of the CPC is that there must be fairness and there must be a just and important thing to have that fairness, and there must be a resolution of the civil dispute, that the civil dispute should be solved with fairness and just. And second, there should be avoidance of procedural delay. There should be no procedural delay. Third, the it is also promoting the efficacy or efficiency of the standardized procedures in the CPC. So if you see the structure of the CPC, it is very beautiful structure. From section 1 to 8 talks about the scope, applicability, and definition. Then talks about the jurisdiction and power of the civil court. If you see part 1 to 11, that is from section 9 to 158, it talks about the jurisdiction of the court, institution of suit, pleadings, appearance, trial, and judgment. And if you see the schedule, it is having or from having containing order, that is from order 1 to order 51. If you see the key principles are nothing but it is to, if there is the right to sue, the civil court must be there for having a civil case on those civil cases who are having the civil cases, but it is in a civil nature, and it is otherwise, if it is not a civil nature, then it will be barred. Jurisdiction, there must be a jurisdiction to the court, that is subject matter jurisdiction, pecuniary jurisdiction, and territorial jurisdiction. The major and the most important thing is res judicata, that is talking about the relitigation. Relitigation, once the case has been decided, then it should not be seen again and it should not be decided again or it should not be heard again. Place of suit, rules on where the suit may be filed, or places where the suit is going to be filed, on which place you are going to file the suit. That is also talking about the place of suit. Pleading is nothing but it contains the claims and as well as the defense which is given under order 6. So this is the key principles of the CPC. If you see the important procedural steps in the whole of the CPC, that is institution of suit, which is given under order 4, that is the filing a plaint to commence the proceeding. Then someone is there, order 5, issuing the summon to the defendant or appeared or to the respondents. Defendant has to appear in the court if the plaintiff has filed the case, or to the respondent. Pleading is given in order 6, order 7, order 8, which includes plaint, written statement, and counterclaims. Interlocutory proceeding, which is very important, that is given under 39, that is temporary relief like injunction. Trial, that is given under order 18, that is the presenting of evidence and examination of witness. Then judgment entered, that is order 20. It has been given by the decision of the courts. There are some special provisions also that there, see, some mistake has been done, something has been done, then the person can go and file the case for doing some amendments, doing some changes. That is nothing but it is the amendment of pleading. Amendment of pleading is under order 6 rule 17. Order 6 rule 17 is nothing but it talks about the modification. It talks about such kind of a thing where you are allowed to go to the court, and when the court has filed, when you have filed the case in the court and it's some modification you want, that you can write an application under order 6 rule 17 that I want the amendment of pleading. Then there is execution of decree. If the order has been given, then how you are going to execute that order? That is nothing but it is execution of decree which is given from order 36, sorry, section 36 to 74, that is order 21. That is mechanism how you are going to enforce the court orders. Then there is appeal. If you are not happy with the orders and all, then you can go and file the appeal. That is given under section 96 to 100A. That is order 41 to 48. Sorry, 47. That is procedure for challenging the decisions. Then there is temporary injunction. Temporary injunction is nothing but it is given under 39, and also it is known as interim orders. Then cost. What cost is to be given? What cost has to be applied? That is given under section 35, 35A, 35B, and how much cost has to be imposed to the award-winning party. That is the that much of the thing, that much of the loss or that much of the compensation has to be given. That is the thing, and that is to be seen very properly and very reasonably. Now, the schedules and the rule. The first schedule is talking about the joining of the party, whom you can join, that is plaintiff. And next is, it is given under order 1. Next is order 14, that is framing of issues. What issues you are going to frame. Such issues you are framed, that which is very much important for you. Another is order 5, that is summon and service. Summon and service is nothing but where you are going to summon it, where you are going to provide the services, that is given under the order 5. And last, discovery, inspection, and interrogatory degree, that is order 9. That is nothing but it is to be seen how you are going to file this degree or how you are going to discover the inspection. That is very much important in order 11, not 9. It is not 9, it is 11. Order 11. Okay. Am I audible to you all?
Yes,
Hello?
sir.
Now, another part is the amendment. Amendment is also one of the important things where the CPC has undergone for so many amendments to enhance the efficiency and reduce the delay. And notable amendment has been done in 2002 as well as in 1976. In 2002, the major thing was addition of arbitration and all. And by this, the CPC has a fundamental, which you can say, the maintaining the procedure discipline in the civil litigation by ensuring the balance between procedural rigidity and flexibility. That is the whole thing. That is the whole scenario. That is the whole brief outcome of the CPC. Tell you if you want to ask anything. A brief of the CPC that I can. Now, the coming to the most important thing, that is from section 1 to 25. See, section 1 is very much structurally, it has been given. It is very clear. If you remember, if you listen it very properly, it is very much easy to grab it. When you remember 1 to 25, the numericals, the thing or the story goes like this. See, first is to introduce how we are going to do. So CPC himself is introducing in section 1 that my name is CPC, and my name is CPC, then I am applicable to whole of India, and now I am also applicable to Jammu and Kashmir, and to such areas that is tribal area which it has not come under the exempted law, or which where the exemption is not there. Then second is talking about what are the important definitions under me. That is decree, that is formal expression of an adjudication determining the right of the parties. Then it also defines decree holder, judgment, debtor, necessary profit, and immediate necessary profit is nothing but it is the intermediate profit. Then it also talks about foreign court, pleader, and public officer. Section 3 talks about the subordination of court. Subordination of court like this, it says in which court you are going to file the cases. So it specifies the hierarchy of the court. It goes like this: civil judge junior division, civil judge senior division, civil judge junior division, civil judge senior division, additional district court or additional district judge court, and then district court or district judges court, and then high court. Like this, the hierarchy goes. And above high court, it is Supreme Court. Section 4 talks about the special law, local law, that is saying, and it is having their own special jurisdiction. For example, revenue. And this application of the revenue code is nothing but it is applicable by the state government in each and every place. Section 6 talks about the pecuniary jurisdiction. It depends upon the state to state what pecuniary jurisdiction and what is applicable to such a state that is given the state. And the state has to tell you about the pecuniary jurisdiction. Provincial small causes code, that is section 7. Section 7 is nothing but it is the provincial small causes code, which talks about the small issue, which talks about the Small Causes Codes Act, that is 1987. Section 8 talks about the presidency small cause code. Presidency small cause code is nothing but it is similar to the exemption what has been given in the section 7. Now the important thing which comes, that comes from section 9. Section 9 says, if you are coming to me then you have to come with such type of dispute which is civil in nature. It means that it is talking about civil suits. Civil suits means that civil court have the jurisdiction over all the suits, but who is having the nature of civil in. And those suits are also not allowed, which is barred by the CPC. So civil nature include disputes relating to property, contract, rights, but excluded the matters like religious or moral obligation. For religious and moral obligation, that there is the, if you have called any pandit to do some havan, until unless there is a contract between, and if he has done the havan and all, he cannot say that you give me the purohits and you give me the money and all. There is some ethical rights, moral rights. For that, if the lady is there and the, as a male you are sitting, the lady cannot go and file the case that why he's sitting if I am standing. This is also a civil thing, but it will not come under the CPC. Section 10, that is stay of suit, or that is also known as a res sub judice. It is preventing the parallel litigation of the same matter. You cannot file the case again and again in the same court, again and again in the same court, as well as the matter once it is going, then it cannot be filed again in the another court. And it also says that is section 10, that is res sub judice, that is, if a suit is already pending in a competent court, then the subsequent suit cannot be filed. Subsequent suit cannot, or subsequent matter cannot be filed. That is not allowed. Res judicata. Res judicata is also one of the important thing. That is the matter that has been finally adjudicated, and it cannot be reopened again in the subsequent suit as between the same parties and the same issue. Same party and same issues are there. Now again, the matter is not going to be open. Section 12 talks about the bar to the further suit. Bar to the further suit means that bar to a fresh suit of same cause of action. Once you have filed, you have lost. Now again, you are coming with the same cause of action, then it is not going to be allowed. 13 is foreign judgment. Foreign judgment is nothing but it is recognized as a conclusive until unless it is obtained by fraud. It has lack of jurisdiction. It violates the principles of the natural justice of the Indian law. Section 48 is to be read with the evidence law, that there is a presumption of the foreign law, that the court presumes that the foreign judgment which has been given or which has been taken, it is correct until and unless it is proved by the other party that it is wrong, or it has been taken by fraud, lack of jurisdiction, or it has violated the principles of the natural justice. Section 15 talks about the court of the lowest grade. Each and every suit has to be filed in that court which is lowest court. It means that if the property dispute is there, for example, if the property dispute is there and the property cost is around 1 crore rupees, so the 1 crore rupees you have to see that which court is having that jurisdiction to take that suit. It can be district court also, it can be civil judges, senior division, it can be ADJ's court, it can be civil just junior division. It depends upon the pecuniary limits, depends upon the state. Section 16 talks about the suits relating to the immovable property. What is the immovable property? The property which cannot be moved from one place to another. It means that the suit related to the Transfer of Property Act. Movable is given in Sales of Goods Act. Immovable is given Transfer of Property Act. So if you see that here, if the property which is being moved from one place to another, that suits can be filed in those jurisdictions where the property is situated. Section 17 talks about immovable property situated in different jurisdictions. For example, if the property is situated, one property X state, one property in Y state, then how the court is going to see. So the suit can be filed in any of the court having the jurisdiction, and the judgment who's come first, that will be binding. That is the immovable property situated in different jurisdictions. Section 18 is place of institution of suit where the local limits are uncertain. Now the suit has been filed. Now the property dispute is in such situation which is on the boundary of the state. Half of the land is in Madhya Pradesh, half of the land is in Uttar Pradesh. Then what? So if the local jurisdiction is uncertain, then the suit can be filed in that jurisdiction where the jurisdiction can be determined. Yes, now it is fine. This suit has been filed here, then That's why it is to be filed in the UP code. 19 talks about the suit of compensation. Suit of compensation is nothing but it is related with the law of torts. Law of torts, if you want to file any suit under law of tort, then suit of compensation section 19 takes the birth, and you can file the case under law of tort, under section 19 for the law of torts. Section 20, the suits which are not covered under 19, then all other suits can be filed under section 20, where it can be related with the defendant's residence, carries where he's carrying the business, where the cause of action has arisen, where the place of action has been taken, all these things. 21 is talking nothing but it is the objection. Objection of what? Objection of jurisdiction. Here you have to take the jurisdictional objection with immediate effect or on the first instance. It allows the party or it allows the party to take the objection regarding the jurisdiction, but it must be raised as earliest as possible or as the earliest opportunity. Otherwise, it will mean that you have been waived. Even the court himself can also take the objection that it is not a right place. You please go and file in the other jurisdiction. Or there can be amendment of pleadings also that I have told you. 22, power to transfer the suit. If the party has filed the suit in such type of jurisdiction where it is a wrong jurisdiction, then the court has the power to transfer the suit from his jurisdiction to that jurisdiction which is an appropriate or which is more convenient. That is allowing a party to request to transfer a suit from one court to another if it is where it is more conveniently seen or discussed or where it is having the jurisdiction. Transfer the suit by the superior courts. It means superior courts are those which courts? High Court and Supreme Court. So they can transfer the suit to the subordinate courts when they are requiring or when they are going to see. Next is general power of transfer. High Court and District Court can transfer or withdraw the case at any stage and transfer them to a competent court. So superior courts mean if there are two high courts and from one high court to another high court it has to be gone. That is section 23. Then Supreme Court will decide. If there are two district courts, then High Court will decide. If there are two local session court, then District Court will decide. Power of Supreme Court is, see, section 25 is a residuary power. Even though 23 has been there, then why to 25? So power of the Supreme Court to transfer a suit for any suit, appeal, proceeding from one state to another if for the interest of justice. This thing can be seen by the example of when wife filed the case against the husband, where wife want to transfer the case to his native place because she cannot travel, she cannot come, she can. But here the transfer can be done by the Supreme Court until and unless the interest of justice is being violated. So these things has to be seen, or these things has to be undertaken into the picture while reading from section 1 to 25, which is very important, as well as you have to see that how these things are going to be used under CPC. So CPC, that section 1, which is talking about the effectiveness, that talks from that it is applicable from 1st January 1909. That is the Act of 1908. I have told you about the definition of decree, order, misne profit, foreign court's judgment. What is decree? It is nothing but it is a formal adjudication of the right in the suit. What is order? Order is nothing but it is a decision of a civil court, but it is not a decree. Decree can be preliminary decree and final decree also. Mesne profit. Mesne profit is nothing but anybody has taken wrongful profits or wrongful gain by the possession of the property which is belonging to another person. Foreign court judgment. Foreign court judgments are judgment which is related outside the India. Subordination, you know that it is from High Court and the subordination of the Supreme Court. So this is the important thing that is to be seen from section 1 to 25. And if you see the important thing, if you relate it with the judiciary, because I came to know that it is the cases related with the judiciary. So if you see the general provisions, so section 2, you should remember where decree, judgment, mesne profit, foreign court, public officer is been discussed. Then section 9, which talks about the jurisdiction of the civil court, 10, which talks about the res sub judice, 11 talks about res judicata, 13 talks about foreign judgment. 14 talks about presumption of the foreign judgment, and 15 to 20 is nothing but it is the place of suing, that is the jurisdiction of the court. Another part which is very much important, that is section 26, that is institution of the suit, where you are going to file the suit. 27 to 29 is nothing but it is the issuance of the service of someone. 33 is decree as well as judgment. 34 is interest. 35 and 35b talks about the cost. Execution of the decree, which is given from section 36 to 60, that is 36 is application of the order. 37 to 39 talks about the courts executing decrees. 47 talks about question to be determined by executing court. 51 talks about power of the court to enforce execution. 60 talks about property liable to be attached for the execution of sale. Then there is the incidental proceeding. Incidental proceeding is nothing but it is a commission, appointment and procedure, which talks about from section 75 to 78. Section 80 is nothing but it is a giving to the notice to the government or public office for being sued. Appeal is being given in 96. 100 is second appeal. 104 is appeal order from which the appeal lie. 107 is power of the appellate court. Review, reference, and revision. That is very important. 13, 113, 114, 115. Reference, review, and revision. Miscellaneous, if you see that section 144, which is nothing but it's talking the restitution. Restitution, that what thing has to be seen. 148 talks about the time, enlargement of the time. 151 is very important, that is inherent power. 152 talks about the amendment of the judgments, order, and decrees. 153 is nothing but it talks about the general power to amend. These are the important sections which you should know when you go for this judicial service examination and all. If you see the orders, order 1, that is parties to the suit. Order 2, framing of suit. Order 3, recognized agents and pleaders. Order 4, that is institution of the suit. Order 5, that is nothing but it is the issue and service of summon. Order 6 is pleadings. What is the pleading? What pleading includes? Order 7 is plaint. Order 8 is written statement and set off and counterclaim. Order 9 talks about the appearance of the party and consequence and non-consequence and non-appearance of the party, as well as order 9 talks of 11 talks about the discovery and inspection. Order 12 talks about the admission. Order 14 talks about settlement of issues. Order 16 talks about summoning and attendance of the witness. Order 19 talks about execution of decree. Order 38 talks about arrest before judgment. Order 39 talks about temporary injunction and interlocutory order. Order 40 is nothing but it is appointment of receiver. So if you see that which thing can be either where you should focus more or where you should see, that is the difference between decree and order, that is section 2, res judicata and res sub judice, that is section 10 and 11, jurisdiction of the court, that is section 15 and 15 to 20, inherent power, that is 151, and execution, that is order 21 and section 36, which has to be read with. So if you want to ask, or if you see, order 8, rule 8 is also one of the important thing where you can say that it is known as representative suit, where the person can file the case. That is also known as PIL in civil suit, where you can file the case in the lower court. That is a different name. It is representative suit. Public interest litigation is in High Court and Supreme Court, but representative suit is the kind of a suit which can be discussed, which can be filed in the civil court. Anybody else?
Sir, is there any important case law that we should keep in mind in
There
regards
are
to?
certain important. There are so many important case laws in CPC. First and the most important related with the that is the advocate case. Then there is a case related with the section 2 clause 2, that is Trojan and Company versus RMN Nagappa Chettiar, that is AIR 1953, where it is been talking about the defined or talking about the essential characteristics of decree, formal adjudication and conclusiveness. Then Dula Bhai versus State of MP 1969, it talks about the jurisdiction of the civil court. Then in section 10, it is Pukhraj D. Jain versus G. Gopal Krishna. Then in section 11, it is Daryao versus State of UP and Satyadhan Ghoshal versus Srimati Drojin Devi. Foreign judgments, it is Narsimha Rao versus Venkata Lakshmi and Hari Singh versus Mohammad Said. Jurisdiction, it is Kusum Ingots and Alloy Limited versus Union of India and Kiran Singh for section 16, Kiran Singh versus Chaman Paswan. Section 94, that is supplemental proceeding. It is Mareva Company, Navera SA versus International Bulk Carrier. It is a international case. Then for execution, it is KK Verma versus Union of India. And section 60, it is Union of India versus SD Sharma. For 151, it is Manohar Lal Chopra versus Raj Bahadur Rao Seth Hira Lal and Padam Sen versus State of UP. For the amendment of pleading, it is Raj Tutu Builder versus Narayan Swamy. For execution of a decree and amendment of pleading, one more cases, that is Shyam Singh versus Collector of District Hamirpur. For temporary injunction, it is Gujarat Bottling Company Limited versus Coca-Cola. For appeal, it is Shiv Shakti Cooperative House versus Cooperative Housing Society versus Swaraj Developer. For second appeal, it is Kondiba Dagadu Kadam versus Savitri Bai Sopan Gujar. For revision, it is Major S.S. Khanna versus Brigadier F.J. Dillon and Binayak Sen versus Ramesh Chandra, which is talking about the restitution, and Salim Advocate Bar Association, which is very important case, that is enlargement of the time, that there can be increase of the time. It is not, there is only 3 times which has been given, that in 3 times there should be the decision of the case. But how many dates can be there? 3. But the enlargement of the time, which is 148, it can be enlarged, and it has been given in the Salim Advocate Bar Association versus Union of India. Other cases which are very much important, that is for your judicial services, that is Salim Advocate. And Salim Advocate, why it is very much important? Because here it has been said that even though the time which has been given, it is in shall, but still it has to be interpreted liberally. It cannot be mandatory. Why? Because every person is not only for the case or going to the case, they have their life. That is the personal life. They have their own right to life and liberty. They have to do with certain other things. It is not only for this that they should come to the court and all. There can be anything. There can be anything which is related to the what I must to say, disputes or enlargement of the time on anything. Yes, anybody? Yes, yes, anybody want to ask anything or say? Yes, anybody can say. No? Should I tell anything about from myself?
Sir, one last question.
Hmm.
Can you like tell the difference between res subjudice and res judicata?
You are in which year?
It was
Have you
this.
have
Yes,
you
sir.
studied CPC? Have you studied
No,
CPC,
sir.
or you are studying for the?
No,
It is
sir.
not a small thing. It is not a small thing that in one important situation I can say. But if you want to remember one thing, that is the difference between um, res judicata and res sub judice. You can write it. For res judicata, it is very important that it is only for the same party and same issue. And for res sub judice, it is for the It is for the same issues again in the different code if it is pending. For res judicata, the matter has already been decided by the competent court, but again you are going for it. It is not allowed. For res judicata, res sub judice, the matter is currently pending in the another court, and you have gone and filed the case in another court. Provision, you know, that is section 11 and section 12. Nature, it is prohibiting the relitigation of the same matter between the same parties. But section 10 says, or rest sub judice, that is, it prevents the simultaneous trial of the same matter in two courts. It is keeping the bar. Applicability, it is applies to the suit that has been finally decided by the competent party, a competent court. It applies to the suit which are pending and not yet decided by the another competent court. Its objectivity is to ensure the finality of the judgment and avoid the multiple litigation of the same issue. In res sub judice, it avoids the conflicting decision if we have filed the multiplicity or multiple suits or multiple proceedings. Condition, same parties or parties claiming under them in res judicata, same subject matter and same cause of action. Final decision by a competent court. For res sub judice, same party or parties claiming under them, same matter is there and suit is pending in another court, that is a competitor, and now you have gone and filed in the another court. What is its effect? Its effect for the judicata, it bars the subsequent suit on the same matter after a final judgment. In res sub judice, it stays the subsequent suit until the prior suit is being decided. And the important case for res judicata is Satyadhan Ghoshal versus Derojan Devi, that is 1960 case, and for res sub judice, it is Pukhraj Dijan versus G. Gopal Krishna, that is in 2004. And if you see the key elements, res judicata applies after a suit which is decided and barring the subsequent suit on the same issue. But res sub judice applies when the suit is pending and the person has gone and filed the parallel litigation on the same. So both the doctrines have the aim to reduce the judicial burden and to ensure the consistency in the judgments. That is the difference between res judicata and res sub judice. Yes. Anything else?
Sir, I think that's it for the query session.
One important thing, that is the caveat. Caveat is also one of the important thing which is given in the CPC, that is given under section 148A. What is caveat? It is a caveat is the legal provision which is been asked by the court to request from a court not to pass an order in a case without giving the prior notice or without giving any prior notice to the person who is lodging the caveat. Caveat is nothing but it's a be aware. Who can file this caveat? Any person who can or who is appearing, who anticipates, they can have the order for being passed against them. The caveat must be filed in the court where the application is expected to be made. The caveat must specify the details of the anticipated application. So what is the procedure of filing the caveat? It is a procedural thing. That is, the caveat must submit the caveat in writing. It should state the litigation. Okay, I will ask this case. I will make this question clear. What you have asked from me, that is easy question. First, I'm telling this thing. The nature of the applicant, that is the caveat is required to serve a notice to the caveat to the applicant or the party expected to file the case. The obligation of the court is to notify the caveator whenever in applicability or whenever against the caveator is made. Duration of the caveat is 90 days. Okay. One question has been asked, sir, in the case of real estate, it is the common practice that the home buyer institutes the cases simultaneously with consumer forum and RERA tribunal. Why it is not barred by the sub judice? Very good question. CPC has been there. CPC is related with the civil disputes, but here there are different jurisdictions. One, it is in consumer forum, which is governed for the Consumer Protection Act. So the forum addresses issues related to the deficiency in service. That's why to protect the rights of the consumer. And this RERA tribunals, it is governed for the regulation development for the real estate. These tribunals handle the issue related to the real estate project, such as delay in possession, non-registration, or unfair practices by the developer. And since these two forums have different types of relief, that is in compensation under Consumer Protection Act and regulatory enforcement under RERA, that's why they do not overlap. And now, why it is not applicable under Section 10? Because the matter in issue is not the same. For res sub judice to apply Section 10, the matter in issue, both the case must be same. Here, RERA's object is different and Consumer Forum's object is different. Here, the subject matter may appear similar, but example, there is a delay in possession, and the nature of relief sought to be on the ground of claim for that is difference between the Consumer Forum and RERA. RERA is giving the relief for what? Delay in possession, non-registration, or unfair thing. Consumer is giving when there is a deficiency in the services. That's why. And here, Consumer Forum is being related with the buyer, which might seek monetary compensation for the mental agony or loss which has been due to the delay. But RERA, here the buyer might demand project completion or refund or adherence to the RERA norm. Here, Section 10 does not apply to special tribunal like Consumer Forum, RERA, and all these things. Section 10 primarily applicable to the civil dispute or the civil suits, and it is within the jurisdiction of the civil court. And here, both the act, that is Consumer Protection Act and RERA, under Section 88 and this RERA, both have the parallel remedies. They are not simultaneously or they are not on the same. And if you want to read more, you can read that Messrs. Imperial Structures Limited versus Anil Patni and Prisoners Urban Land and Infrastructure Limited versus Union of India, as well as Aftab Singh versus MRMGF Land and CDRC. That is, so simultaneously, if I might say, as a conclusion, that it is a simultaneous proceeding under Consumer Forum Act and RERA Tribunal. They are having distinct forums. These governing statute give the is explicting the parallel remedies, as well as the principle of res sub judice and res judicata does not apply strictly on these things. Anybody else want to ask anything? Yes. Yes, you may. Say. Anybody else? Or should we end it?
So what is execution of decree?
What is execution? See, when the court has given the order, then how you are going to execute it? In what is your name? And in which year you are?
So I'm Benish Khan.
Huh? In which year you are?
So almost I have in last sem.
So I think that it is the most easy question then. From which college you are? Okay, no
I am
problem.
from Jammu Kashmir, Srinagar.
Okay.
I'm
See,
from
no problem. No problem. No problem. See, execution of decree relates with the execution. It refers to the decree or order of the court which is in force. If you have got the order, how you are going to execute it then? हाथ में तो आ गया लेकिन अब क्या करोगे उसको रखोगे तो you have to go somewhere ना. So it enables the decree holder, the person in whose favor the decree is passed, to recover the benefits of the things which has to be given to him. And the section is from section 36 to 74, that is order 21 of the CPC. Decree is a formal adjudication of the right of the parties concerning the subject matter of the suit. That is given under section 2 clause 2. There are three types of decree. Preliminary decree, where it requires the further proceeding before final determination. Final decree, conclusive. Ex parte decree, one party is absent. That is the absence of the defendant. What is order then? Order is the formal expression of a court's decision. on procedural or interlocutory matter, which may be executed under certain condition. Then there is decree holder, in whose favor the decree has been passed, that is section 2(3). And then there is a judgment debtor. What is judgment debtor? It is given under section 2(10), against the person against whom the decree is executed. This is the important. Now, if you see the difference, by difference you will be able to understand more thing. When we talk about the comparison of decree and execution, that is definition is been given under section 2 clause 2, that is decree, and how it has to be execution, or how the execution has to be seen, the process by which the court enforces or implements the decree or order which has been passed. The objectivity under decree is that it establishes the legal right and obligation of the party after the adjudication of suit, but it enforces the decree to enforce the decree holder to get the benefit. Nature is nothing but it is the process of the final in nature. In execution, it has been decree has been passed. Parties who are involved, those who have to see, it involves decree. In execution, decree holder is there and judgment debtor is there. Decree holder in whose favor the decree has been passed, judgment debtor against whom the judgment has been given. Relevant provision in section 2 clause 2, section 33 to 34, and section 36 to 74 of CPC, and order 21 talks about the execution. And if you see, decree is the outcome of the judicial process and specifies what is to be done, while execution ensures that what is directed by the decree it is actually done. So both are interconnected stage in civil litigation, where it is practically it affects the decree. Now there is a difference between decree and order also. If you see the difference between decree and order, it is very easy. Both are having very minor differences. If you see decree is what I have told you, it is given under section 2 clause 2. But what is order? It is given under 2 clause 40. That is the formal decision. But the decree is related to the substantive right. Order is procedural part. Decree is related to the conclusiveness, but order is not conclusive. Decree may be preliminary or final, but order may be interlocutory or final. Decree is having 3 elements. One, it may be formal adjudication, it determines the right in a suit, and it can be conclusive in nature. But order, it is always related to the procedural or interlocutory, and there is no conclusive divinity. There can be more than one decree, but there cannot be multiple orders. There are preliminary decree, final decree, ex parte decree, but orders are not classified. It can be either interim or final. It is applicable under section 96 unless it is barred, that is decree, but the specific orders are appealable under section 104, that is order 43 rule 1. But decree, it is appealable under section 96 until unless it is barred. Case laws are RM Nagappa versus RM Nagappa case and Abdul Rahman versus DK Kazim. So if you see the key difference, the substance as well as the procedure, a decree deals with the substantive right of the party, whereas order, it deals with the procedural matter or auxiliary issue. Conclusivity, decree is conclusive, order is not conclusive, maybe, may not, because it is appealable. Appealability, all decrees are generally appealable, but it is not necessary that all the specific orders are appealable as per the CPC until unless it has been provided. It stops the multiplicity. Only one decree can exist in a suit, either preliminary or final, but there cannot be a multiple order. Multiple order may be passed during the suits, but the decree is one that is final or preliminary. I think it is clear to you.
Okay, so yes, sir, it's clear about me. Thank you, sir.
Anybody else? Yes. One question is this, sir. Recently, JNK ruled that res judicata is inapplicable in domestic violence cases and says that it does not apply to DV Act and any special code, any special act be left from its application. Whether it can be applied? Again, apply the same thing. Res judicata is for what? Section 11, domestic violence is for what? For the domestic purpose. Res judicata is the statutory provision. This DV is based on the act. The Jammu Kashmir Act, what they have said, it has clarified that aggrieved person, which has been written, provide the valid reason for withdrawing a previous petition and subsequently filing a new petition in the DV Act. So the doctrine of res judicata may not bar that petition. So here the court has emphasized the DV Act for the purpose to offer the immediate and effective relief to the victim, and technical objections like res judicata should not hinder the objectivity. So the doctrine of res judicata is a fundamental principle to ensure the finality in the litigation, but its application under statute like DV Act, anything, it cannot be used. It may be applicable. Clear? Anything else? So should we end it?
Sir, how we can file an objection in matrimonial dispute?
Matrimonial disputes are having its own family law. There is a separate act. Only one thing you can file in CPC, transferring of the matrimonial disputes under section 25.
Okay, sir.
Okay. And
Okay,
even the
sir.
miscellaneous profit can also be filed. That is the maintenance or something related to the women's right, related to the pecuniary. Okay. Done.
Okay, sir, done.
Thank you.